Welcome to In the Name of the Law with your host, Lisa Speaker from Speaker Law Firm. Joining her today is Stephen Sinus from Sinus Dramus Law Firm, along with Mary Chartier and Takura Nyemphakusa from Chartier Nyemphakusa PLC. Now let's discuss some remarkable stories and real cases.
Welcome to In the Name of the Law. Today we're going to be talking about semi-truck accidents, when juveniles get in trouble with the law and at school, and parental alienation in family law cases.
In the name of personal injury law.
Unfortunately, semi-truck accidents often result in serious and life-altering injuries that require medical care and treatment. So today we're going to talk with Steve Sinus, a personal injury attorney at the Sinus Dramus Law Firm, to tell us about how the Michigan no-fault law works with respect to these very serious semi-truck auto accidents.
Thanks for having me.
So tell us, how does the Michigan no-fault law apply in a semi-truck accident situation?
So semi-truck accident cases are unique cases for a lot of different reasons. But one thing people should understand who are injured in these accidents is that the Michigan no-fault law governs many of their rights that they have to pursue. And you can't really handle one of these cases without fully appreciating and applying the Michigan no-fault law in all respects. So getting into it a little bit further, the reason why the no-fault law applies is that it's the law that governs the claims people have for any type of injury they sustain arising out of the use of a motor vehicle. And the semi-truck in a particular accident is always going to be a motor vehicle. So the no-fault law is then applicable, and it determines the person's rights for their no-fault PIP benefits and also their rights against the at-fault semi-truck driver and the company involved.
So what are the PIP benefits, and are they available to the semi-truck accident cases?
Yes, so no-fault PIP benefits are these unique benefits people can pursue under the Michigan No-Fault Act. They're called first-party benefits, and if you're injured in a semi-truck accident, you can pursue these benefits. And actually, the person who's at fault for the semi-truck accident can pursue these benefits. That's why they're called no-fault benefits. So there are some categories of people who can be disqualified from no-fault PIP benefits. Like if you own a vehicle that you're using and it's uninsured, you can be disqualified. If you're using a stolen vehicle at the time of the semi-truck accident, you can be disqualified from no-fault PIP benefits. But the issue of fault doesn't determine whether or not those benefits are payable. If you're in an accident, semi-truck accident, you're going to get no-fault PIP benefits unless you're not disqualified.
And semi-truck accidents have to be really horrific. Like, you're going to have a lot of medical treatments going to be needed, right?
Right, and that's why you have to first understand no-fault PIP benefits. So let me quickly summarize those. There are four main no-fault PIP benefits. One is the survivor's loss benefit, which applies in cases involving death. But if you survive a crash, you have these other three benefits. One is known as the work loss benefit, which covers your loss of income from work you would have performed if you were not injured. So if you're injured in a semi-truck accident, you can pursue work loss through your no-fault coverage, which, by the way, these no-fault PIP benefits are payable by your own insurance company typically. There's some exceptions to that rule, but most of the time you're going to turn to your own insurance company. So if you can't work, you can pursue loss of income for up to 3 years, and it's capped at 85% of your gross income, and there's also about a $6,000 monthly max. So if you can't work because you're injured as a result of a negligent semi-truck driver, your first place to stop for income loss is going to be with your own insurance company for work loss benefits. And that's a no-fault PIP benefit. Another no-fault PIP benefit is for household services you can't perform on your own, known as a replacement service. So if you can't mow your yard or clean your kitchen or things of that nature and you need somebody else to do it, you can have coverage for up to $20 a day for 3 years to pay people to do those services for you. But the main hallmark of the no-fault system is known as the allowable expense benefit. So to your point, if you're catastrophically injured in a semi-truck accident, you're going to need a lot of care and treatment. And the allowable expense benefit says that you can claim whatever is reasonably necessary for your care, recovery, or rehabilitation of your injuries. So when I'm talking to somebody who's just been severely injured in a semi-truck accident, I'm first telling them about this allowable expense benefit because it can cover so much, not just the medical treatment in the hospital, but the rehab services, the care at home, home modifications, vehicle accommodations, home accessibility issues can be paid for. So there's all types of resources that can be there for those who are catastrophically injured in a semi-truck accident through the allowable expense benefit. But I just want to add that the 2019 reforms to the no-fault law allows people to buy less than lifetime coverage for allowable expense benefits. So there's this issue now where we have to look into people's insurance coverage to determine whether or not they've limited their allowable expense benefit coverage, or do they have lifetime? And that's a big issue in a semi-truck accident case.
Right, and so with the new law where it's limiting potentially the PIP benefits, they have to then turn to somebody else to get the coverage. So tell us how the Michigan no-fault law works in those negligent semi-truck cases.
That's right. And so I started with the no-fault PIP benefits because you have to understand those first. But because the new law allows us to limit our medical expense coverage, say you bought a $50,000 amount of allowable expense coverage, or $250,000, or you opted out, which some people can do. If you're not covered, you can pursue those allowable expenses from the at-fault semi-truck driver or the company involved. And so when you look at the situation of somebody who doesn't have coverage through the no-fault system or enough coverage, they then pursue essentially their no-fault benefits from the semi-truck company. And that's what requires attorneys handling these cases to really appreciate the nuances of the no-fault law, because it's those nuances that guides what they can actually claim for medical expenses in the negligence case against the semi-truck driver and company involved.
Can you explain how the pain and suffering aspect works in a Michigan no-fault case when it's a semi-truck accident?
Yeah, and so it's not just no-fault PIP benefits that are governed by the no-fault law. The no-fault law actually dictates the rules that apply to the damages that you pursue in the negligence case. So when a person is severely injured as a result of a negligent semi-truck driver, they can pursue pain and suffering damages, but the no-fault law says they can only do so if they've been seriously injured. Death is one itemized serious injury under the no-fault law. But if you survive, you either have to show that you have a permanent serious disfigurement, which is like a scar or a serious burn or an amputation, or you have to have a serious impairment of body function. And then there's a very particular test that applies to how the serious impairment of body function standard is interpreted by the courts. And this is just another example of where if you're injured in a semi-truck accident, you need to make sure that your lawyer not just knows negligence law, but also the no-fault law and the unique standards that apply, such as the serious injury rule, so that your case can be properly worked up. Because if you can't pass the serious injury rule, you don't get pain and suffering damages from the at-fault semi-truck driver. There's just no ability to recover those damages.
And how does the Michigan no-fault law play into the lost income that maybe the injured accident victim from a semi-truck accident has?
So you may remember I said that you had 3 years of work loss benefits, right, capped at 85% of your gross income, subject to a $6,000 cap. That's all on the no-fault side. Well, what if you have income loss over and above that?
Beyond 3 years, right?
Right, beyond 3 years or beyond the $6,000 cap. That's income loss you can pursue against the at-fault semi-truck driver. But that's a tort damage that's pursued in the negligence case.
And anything more about medical expense claims and how that plays into a semi-truck accident case?
It's now more important than ever that people who are injured in motor vehicle accidents involving a semi-truck look at their allowable expense coverage and understand what their coverage is so they can pursue their care. But then also make sure that they get an attorney who can really deal with the nuances that are there under the law that govern their right to pursue their uncovered medical expenses from the semi-truck driver. And this is a new feature of the no-fault law. And so it's not just about finding an attorney who can handle semi-truck cases. It's one who can handle semi-truck cases and knows all about the no-fault law. That's essential for people who are looking for legal representation.
And what about before an accident? What can our viewers do to help themselves down the road if they ever have an accident like this?
Be safe, drive defensively, and watch out for semi-trucks. Okay. Thanks.
Thank you, Steve.
In the Name of Personal Injury Law is brought to you by the Sinus Dramus Law Firm. In the Name of Criminal Defense.
Some politicians and media performers have been claiming that juvenile crime rates are sky high. Today we have with us Mary Chartier and Takura Nyamfukuza of Chartier Nyamfukuza to talk about this issue and how to help juveniles and their parents protect themselves from the criminal prosecution system. Welcome back.
Thank you, Lisa.
So Mary, your firm works with juveniles, right?
We do.
Okay. So are the crime rates for juveniles skyrocketing?
No. I mean, you wouldn't know that if you watch certain people on television or certain political ads, but they're not. So both the FBI and the Justice Department track crime statistics every year. In the last 20 years, the crime rate for juveniles is essentially half. And in 2020, it was down even from 2019. So the notion of this skyrocketing crime rate for juveniles is false when we look at studies and statistics that have objectively examined this issue.
So even though juvenile crime rates are not increasing, juveniles could still be arrested, charged, and convicted, right? So let's talk about the schools and what parents should be aware of. So do the school officials need to obtain a warrant to search students under their authority?
So the short answer is no, because of a doctrine called in loco parentis. I had to dust off my Black's Law dictionary for that one. And it means essentially, when parents send their children off to the school officials are acting in place of the parents. And the burden of proof in legalese is reasonable suspicion, which is lower than the warrant requirement. And essentially, the level of intrusiveness that courts will allow would depend on the age of the child and also the nature of the allegation that's involved. But my advice, whether it's a juvenile or an adult, is don't talk, right? And certainly for a student, don't talk without your parents. And if at all possible, wait until there's an attorney present.
So a student can not only ask for their parent to be present, but they can also ask for an attorney?
Absolutely.
Yes, and they should, because students face so many serious charges. They face allegations of assault, sexual assaults, sexting, theft, just like adults. And the ramifications for them are enormous if they are found to have committed these offenses.
So let's talk a little bit more about the sexting allegations.
Oh, so sexting is probably one of the areas that there are so many misconceptions on. And what generally goes along with text messaging or Snapchat messaging or instant messaging on Facebook or any other type of communication would be nudes. And this certainly wasn't going on when I was in school because we didn't have cell phones or anything like that. But you'll get a lot of either people sending nudes unsolicited or requesting nudes and getting them. And what people don't realize is that's actually child pornography. And in Michigan state courts, it's formally known as child sexually abusive material. And it doesn't matter if it's consensual or not. The age of consent to send someone a nude would be 18. So if a 17-year-old is requesting a 16-year-old to send nudes, the 17-year-old is on the hook for a very serious felony and the 16-year-old for sending them. And this is not just a hypothetical. We see cases all the time where both state prosecutors and sometimes federal prosecutors are charging these, and it's a really serious penalty.
So going back to the schools, can conduct that occurs away from the school building still result in sanctions at school?
Oh, it most certainly can. Think about assaults and drug use, especially with Snapchat. And it seems like every week we learn about a new different social media application when we're in court. But yes, absolutely. With the proliferation of all these apps, school officials want to ensure that stuff that happens off campus, rather, doesn't come onto the property of the school and cause disruptions.
And one of the things about those messaging systems is a lot of people think, especially with Snapchat, well, it was on Snapchat, so no one can get it. Well, first of all, you can save images on Snapchat, so you don't know if the other person is saving an image or not, or saving a chat. But the other thing is the government can get a search warrant, send it to Snapchat, and despite what Snapchat tells you, they can obtain a lot from Snapchat. They might not be able to obtain everything, but they can obtain a lot. And that's one of the biggest misconceptions also that people have. Someone will say, well, it was on Snapchat. For years, it was WhatsApp. Oh, it was on WhatsApp. They can't get that. Well, of course they can. So none of that is really safe. There's no safe method to send nudes. The reality is if you're under 18, no sending of nudes. And the other sort of interesting twist is the age of consent for penetration is 16 in the state of Michigan. But even if a couple is having a consensual sexual relationship when they're 16 or 17, they still can't exchange nudes.
So what about free speech with some of these sexting messages?
Well, recently, there was 2021. There was
recent.
Yes. Just want to be precise, right? Numbers matter. There was a United States Supreme Court case called Mahoney Area School District versus BL. BL being the name of the minor who took great exception to not making the cheerleading squad. She went on none other than Snapchat and voiced her displeasure.
I can understand that. I'd be down if I didn't make the cheerleading squad too,
Right. I didn't make it either, although I've been told I have great legs. But she took great exception to not making the cheerleading squad, and she was suspended ultimately. The High Court decided that because this happened under circumstances where her parents, instead of the school, should have been in control of, the language that she was using, that the school went perhaps a little bit too far. And also because the precise nature of what it is that she said really didn't threaten anybody's safety or impede the ability of the authorities to manage all the students on the property. But again, a lot of time and a lot of money was spent on that, and it's better just not to find yourself in that circumstance.
So she did have the right to say what she did, but you got to be careful because it's easy to cross a line.
It is, right? She used a lot of profanity in her messages, and so the court stood up for the use of profanity and for the right of a student to express displeasure at her school. I think the key that they found in that case, and correct me if I'm wrong, was that she wasn't disrupting the school. She was expressing her viewpoint, which she had the First Amendment right to do, but there was no disruption of the school. That is a fine line when you start getting into something that could be perceived as a threat or a possible threat, especially in this day and age with school shootings. Mm-hmm. So while what she did wasn't disruptive, the next student could certainly go up to or even cross that line.
Right. So if a juvenile gets into legal trouble, what can the juvenile and the parents expect?
So in October of 2021, Raise the Age is the name of the legislation. But before that legislation, 17 was the magic number where an individual would be considered an adult for purposes of criminal prosecution here in Michigan. So, except in specific circumstances now, the most heinous crimes, 17-year-olds now are still have access to all the treatment and resources that other juveniles have. Also, it means fewer people will enter the criminal prosecution system, as we call it, and again, not being marked with that scarlet letter is something that will certainly, I think people will appreciate long after they're out of the system. Because once you're in the system, as we know, Mary, it's difficult to get out.
Right. And because juveniles face the possibility of being locked up too. And so it's very concerning and very serious. And as you know, Lisa, we've defended numerous juveniles and adults, and we discuss these matters and more on our podcast, Constitutional Defenders.
Good, I'll check it out. Thank you.
In the Name of Criminal Defense is brought to you by Chartier Niamh-Fakusa, PLC. Go to WLAJ.com for more information on today's topics and to view other In the Name of the Law episodes. In the Name of Family Law.
Today on In the Name of Family Law, we're going to talk about a topic that comes up a lot in high conflict custody cases. I have with me attorney Connie Thacker, who is an attorney that does family law in Grand Rapids at the law firm of Thacker Slate. And welcome, Connie.
Thank you.
So Connie has worked on a lot of parental alienation cases, both representing the targeted parent, the alienating parent, and in some cases even serving as a guardian ad litem to give the judge a recommendation about what's in the best interest of the child. So Connie, I really wanted to have you here because you can represent all spectrums of what you've seen in these types of high conflict cases. So can you start off by telling us what is parental alienation as used in the family court system?
Well, thank you for having me, and that's really an interesting question because I think that psychologists and judges and lawyers and guardian ad litems use this phrase it's appropriate and when it's not appropriate. And I think it's important to know a little bit of the history in terms of when it started, right? So in the 1970s, they look back and they see women who became liberated in their marriages and decided they didn't want to be married anymore and they wanted to move on in themselves and get jobs and those kinds of things. And we also saw in the 70s the elimination of no-fault divorces. Okay, so now we have women that are getting divorced and now they're in conflict with their husbands. And so this concept was created by Johnston and Kelly back in the 70s that we might have a parental alienation if the child is not wanting to go with the other parent. Okay, so
you mean for parenting time?
For parenting time, yeah. It's not necessarily the label custody, but just we're talking parenting time. The child doesn't want to go for whatever reason, okay? And so the other parent starts this concept of, well, this is parental alienation, and what does that mean? That means that the other parent is trying to sabotage the child to not want to go with that other parent, okay? So the parents are in the middle of this high conflict divorce. They're going back and forth with this child or with the children in terms of where they're going to end up and how often they're going to be there. And then we saw Richard Gardner in the 80s come up with this concept of brainwashing, right? So he added the brainwashing concept to it to say that you're actually brainwashing the child not to go. But interestingly enough, Mr. Gardner had some of his own mental health issues and committed suicide. So you do see some issues of mental health is paramount to this process. And you see it come up a lot. It used to be 20 years ago, we'd hear about domestic abuse all the time. Now we see this sort of swing the other direction with dads of parental alienation. And you can get yourself into these cases very quickly just by a claim or an allegation that the child doesn't want to go. We see it more often when the child is refusing absolutely to go, not that they're going, but that they absolutely refuse to go with that other parent. But where I think the courts make a big mistake, parties and parents make a big mistake, is applying a label. And they want to give it this label of parental alienation, or they want to give it a label of domestic abuse. And then once you get the label, the question is, how do you treat the condition, right? And there's so many methods that the courts have used to treat the problem, and they don't always work. So what we often see is the litigation is crazy expensive. We've got psychologists involved. We've got, parenting time counselors involved. We've got reunification counselors involved. We've got guardian ad litems involved. We're in the court system all the time, and the judges get fatigued, litigation fatigued with these cases because they're there. I tell these people often, you can have as much justice as you can afford. This is going to be an expensive process, and you better battle up and get ready for the cost that's going to be involved. And with parental alienation cases, if that's even the term to use, that's what's being used now, right? The DSM-5 refused to put it in as a diagnosis. Some states are now refusing to even see it as a diagnosis and are holding counselors responsible for using it as a diagnosis in their treatment and fining them and sanctioning them because it hasn't been really tested. Right?
Right. I mean, I like the thing you said about labeling, because I've seen cases in our office where somebody in the court system, and maybe it was somebody that was reviewing the case internally at the courthouse, decides to slap the label of parental alienation on a case when there wasn't really any supporting evidence. Like the mom, well, we think the mom did something that maybe the dad didn't like.
Right.
But what did it have to do with the child? And there was no expert testimony or any information to really support that quote unquote label. But once the label got put on the case, that escalated the case tremendously.
Yes.
And it stuck. It took a reversal from the Court of Appeals, but it stuck for a really long time.
That's why you've got to be so careful. You have to have the right lawyers looking at what's going on with the case. You can't just say the child won't go, so therefore this is parental alienation. The question is, for parental alienation, even as we talk about it today, it's the unjustified reasons not to go to parenting time. Okay, they're not justified. So we know from the literature that you should look to several things. Was there any sexual abuse? Was there any psychological abuse by a parent? Does one parent have a mental health problem? Mm-hmm. We should be evaluating the competency of the parents from a psychological perspective as well as the child, and then looking at, is this just bad parenting? You can be 30, 40, 50 years old and be a parent and still be a bad parent and have huge consequences, psychological trauma to the child. How you speak to them, even through their today's day and age, is social media, right? The parents texting the child, I'm going to take you and your mom to court if you don't come over here for parenting time. We see those kinds of cases often, but you can't just get a label. The lawyers in the court system really needs to delve into it more than what they're doing. Just because a child isn't going doesn't mean that that's an alienation case. It's why. Right. Why are they not going?
So let's talk about what kind of types of activities might one parent be engaging in that would trigger the courts or the attorneys to be thinking that maybe there is parental alienation here. And I know your position has evolved tremendously over the years, but like what type of actions might give us pause to say that something's going on? It may not be parental alienation, but maybe one parent is trying to disrupt the parent-child relationship, whether it's working or not.
Yeah, you really have to look at those relationships, right? And relationships are key to the whole process. What was the relationship like during the marriage? What's the relationship like now? Why is the couple getting divorced? What happened in the relationship itself to cause this turnaround that the child just says, I don't want to go? And it's more than just, I don't like mom's dog, and so I don't want to go over there. These are, reasons that are tantamount that they just absolutely do not want to have any contact with that parent. And at that stage, you really have to back off a little bit and say, why? From a psychological perspective, what is this kid saying? But we miss that step often because the child's not interviewed, right? Mm-hmm. It's the allegations that are made in court. Child's not coming. We say it's parental alienation. We stick a label on it. We send them off to parental reunification therapy, which we really don't even know what that means this day and age. And the child is there sometimes with the unfavored parent. And it just creates chaos. What I've seen that works better than that process is creating more of a family therapy process. It's labor intensive, it's expensive, but one parent has a counselor, the other parent has a counselor, the child's got a counselor, and we've got a team of people trying to figure out what's going on. And I've even seen in cases when I've represented in parental alienation cases, those are different because I can put a parent on the stand and she can actually say, I don't want my kids to have a relationship with dad. That's different than another case that I have where that doesn't happen.
Right. Well, thank you, Connie. This has been really helpful. Hopefully we'll get this sorted out in the future.
Thank you very much. It's very complicated.
In the Name of Family Law is brought to you by Speaker Law Firm.
Thank you for joining us on In the Name of the Law. See you next week.
Thank you for joining us today for In the Name of the Law. Please go to WLAJ.com for more information on today's topics, and please join us next week for another informative show.